Well, hello friends, and welcome to another WSIB Truth Matters with Joe Machado on this beautiful spring Wednesday. The weather is beautiful outside, so I think spring is finally here to stay. I know that as well because my wife was doing some gardening on the weekend, and that's a good sign that not only are we going to have good vegetables to eat throughout the summer, but also that the springtime is here. Which is one of my favorite times of the year because I get to start golfing again. So anyway, my friends, today I'm going to talk about, this is the second episode of the changes, or I'm talking about changes that are going or are being made to the WSIB's Appeal Services division in terms of the process. This is a result of the value for money audit that took place last year, and some of the results of which the WSIB is trying to implement certain policies or processes that were recommended by that report, which I think is totally in their favor. I don't think that there's a whole lot there that's going to be of benefit to injured workers. And as well as these changes that are being made to the appeal process, I think it's just making the system more complicated. This is an already very complicated system, which is governed by a complex set of laws. With the WSIB Act, the Workers' Compensation Act before that, I know that thousands of injured workers struggle with not only understanding the decisions that are made to deny their claim or some entitlement in their claim, let alone what to do when that happens and how to appeal. They make it sound very simple, but it's not. I've been doing this for over 30 years, and even some of the seasoned paralegals and lawyers that I've known over the years, and I see their work and a lot of the files that I review and case audits that I do for our members. If they struggle with understanding the process, then how the hell is an injured worker going to do that? But the best bet is to make sure that you do have representation if you decide that you want to appeal your claim. And I'm saying this, I'm not trying to force you to get representation, but in my experience, it's probably the best thing to do because it's not easy dealing with these people, and with some of the changes that they're making to the appeals process, I think it's going to be more complex, more complicated, and it's going to add more time to the process, which means more waiting time for you to get justice in your claim. I know the WSIB Appeals Services Division, a lot of their AROs disagree with my views and my thoughts and opinions. And while this is my salute to them, I don't really give a rat's ass what they think about me. It really doesn't matter. What matters is how I'm able to help you in the most simplest manner to get access in your claim, period. That's really why I do this. So last week I talked about the process that takes place in the operating level. So the operating level, you probably have heard decision makers refer to that. That's where all of the initial entitlement decisions and the case management of your case is handled. So eligibility adjudicators, case managers, return to work specialists, managers when they're rendering reconsideration decisions, and everybody else up the chain, and of course the fat cats, and you've heard me talk about the fat cats in my episodes. I do those on Friday. If you haven't watched the last Fridays, you want to watch it for sure. But that's where the operating level is. So we talked about the process, the appeal process at that level. And so we're going to talk today, or I'm going to talk today about the what happens when the appeal is actually at the appeals branch, and it's been assigned to what they call or refer to now as a triage or a triage person, which is generally an appeals resolution officer. And so this is point number 7 in their materials that they emailed me after the Zoom meeting that I attended with the appeals branch a couple of weeks ago. So I want to tell you that everything that I talk about on this channel, all of the information that I provide you with, it's all based on my own opinions, based on over 30 years of dealing with these two organizations, the Workplace Safety and Insurance Board and the Workplace Safety and Insurance Appeals Tribunal. At one point, I had the largest paralegal firm in Ontario with more than 10,000 clients all over the province, and a team of paralegals and other support staff of over 20 to manage that large a caseload. So I'm very familiar with the laws, but I must inform you that these are my own opinions, and you may not always have to take them or agree with them, but I do provide them with the best of intentions, which is to help you. So point number 7, method of resolution and appeal register. So when your appeal is now with the appeal of the triage, and if you haven't watched my last week's episode, you want to watch that so that you can become familiarized with what happens and the changes that are taking place at the operating level. So number 7, if it's a single party appeal, the intake triage determines method of resolution. So in other words, a hearing in writing or an oral hearing. Those are the two methods of hearings that can take place at the Workplace Safety and Insurance Board. If it's a two-party appeal, and that means that if there's a two-party appeal, that there is a respondent in the appeal, which in most cases is the employer. In a two-party appeal, the intake triage recommends a method of resolution with decision pending return to respondent form. That's the form that must be submitted by the respondent. So in this case, you as the injured or ill worker would be, or the estate of a worker would be the appellant, would be appealing, or the appellant, and the responding party, which in most cases is the employer, would be the respondent to the appeal. So when the appeal readiness has been confirmed, a registration letter will be sent to the parties by the intake triage role. The letter will confirm the issues under appeal. It may also include the remedy sought and supplementary information that may be required to implement the decision. So I talked at length, and they mention this quite often in the first part of this series, where they're always going to try and find or remind you to provide information that they should have in the event that the decision is made and it's made in your favor, so that the implementation team can expedite that process. For single party appeals, the letter will also confirm the method of resolution. If the appeal agenda includes one of the 8 return to work issues outlined in step 4, the intake triage role will notify the appeals coordinator that this is a priority return to work appeal and should be expedited. The appeal is then registered as a priority referral. So basically what that means is that any appeal that deals with return to work issues, and they're basically listed in the previous episode, those are considered priority appeals, and they must be handled within, or the appeal time limit is 30 days, and they must be handled on a priority basis so that the appeal can proceed with minimal delays. In this next section, number 8, talks about the share and disclose submissions and rebuttals, and this is dealing with priority appeals. So if the expedited return to work appeal process applies after the appeal is registered, if there is a participant, the appeals coordinator will contact the injured or ill person or their representative to see if they consent to the release of medical information. There is information on the WSIB's website in the appeals practice procedures document that talks about the release of medical and what you can or cannot do. Once consent has been granted, the appeals coordinator contacts ASIS, and a copy of the respondent form and claim file will be sent to the participating party on an expedited basis. If the method of resolution is by hearing in writing, the appeals coordinator will wait for submissions and follow the current rebuttal new information process. So that's basically a rebuttal from the respondent that's being provided, or the appellant, if you're the appellant in this case. Once the submissions have been received or the hearing has been scheduled, the appeals coordinator will prioritize the assignment to an appeals resolution officer. If the expedited return to work appeal process does not apply, then the current process for share and disclosure is followed. And again, the current process is outlined in the appeal practice procedure document in the WSIB's appeals branch. So section number 9, method of resolution with respect to two-party appeals. The respondent form is reviewed with the intake triage recommendation. They refer to step 6 again in this part. So that's what the appeals triage individual is reviewing to determine the flow of the appeal at that point. If the respondent has provided substantial new information or arguments about the objecting party's request method of resolution, a secondary review of the intake triage role may take place, which again, I think just adds to the already delays that are going to be inherent in this process and making it more complex. I think that the respondent has been provided with ample opportunity throughout the process to notify their intentions to provide submissions without having to be given the benefit of potentially causing more delays in the process. But anyway, again, this is the way I see it. Otherwise, the method of resolution will be confirmed for the parties in writing. An oral hearing, the appeals coordinator will contact the objecting party and the respondent, if participating, to schedule a hearing at the first available hearing date for all parties. A letter is sent confirming the date and location of the hearing. And again, as you can tell, and once you go back, if you haven't reviewed the first part of the series, you're going to see that there are a lot of steps, and why, I don't understand, but that's just the way it is. So number 10, we finally get to the decision, which is essentially what you're looking for. And in my opinion, could have been done more expeditiously. Certainly. I have expressed my views as to why I believe that the Appeals Services Division should be gone. I don't see that there any benefit or provide any value whatsoever for injured workers and even employers. I think that the continued creation of processes that only cause further delays and opportunities for the person to basically just quit is just outrageous. But here we go. This is what they this is what they do, and we do have ways to punch through all of this bullshit with my company WSIB Settlements, and they don't like what we do, but it forces them to punch through the bullshit. Anyway, the decision. In the written decision, the appeals resolution officer will explicitly address the remedy sought and communicate whether the decision appears appears ready to implement based on their review of the file. The appeals resolution officer's determination of the readiness to implement and or missing information will be administrative in nature and not a binding decision. So put it back in the hands of the original decision makers. The appeals resolution officer will reference documented conversations and communication with the parties through the customer-facing decision maker or intake triage role related to implementing requirements, if these have taken place. The appeals resolution officer will also comment on whether the request information has submitted to the file. If the decision is ready to be implemented, a 30-day time frame for implementation will be provided. If the decision is not ready to be implemented, the decision maker will note that the decision will be implemented when the required information is received. The appeal resolution officer will also note whether the decision appears ready to implement when referring for implementation. So all of that I just read to you that was on that section on the screen here is complete horseshit. It's just a bunch of confusing fucking words put together with all of the shit that could have been done up front in 1 or 2 steps. And it should not be a situation where it is being used to create more delays, more steps, more calls, more reviews. It's mind-boggling. And as I've said before, if the WSIB took all of those resources that they are allocating to the Appeal Services Division, which is, as far as I'm concerned, totally useless, and they allocated all of those resources to the frontline people, meaning that they would be the front line and the first level of decision makers in a claim. So all of the most or so-called experienced people that they have in the appeals branch, if they were the frontline people, give them the salary they're paying appeals resolution officers anyway. I don't really give a shit because as far as I'm concerned, it's far too much. But anyway, have them be the first level of decision makers, because that first decision is the most important decision. And if they're equipped to become a triage person in this new process, to review all of the information, to make sure that the decision was law or supported by law. In other words, that it was within the Workplace Safety and Insurance Act or the Workers' Compensation Act. And if it was within the policies that have been written and are extensively documented all over the WSIB's website. These people should be knowledgeable. If I know all of those policies and I know how they function and I know every section of the Act talking about claims from pre-1990 to date in all 3 major legislative amendments, if these people are the frontline decision makers and they're given the ability to assess evidence and to make judgments based on looking at the evidence, but based on looking at the law and making those decisions in a timely manner to ensure minimal errors are made. And if after that takes place, there is a need for reconsideration, then there could be what they're calling managers or directors, these so-called knowledgeable people. Then that level could be the function of those individuals who presumably have more experience to basically go over that initial decision, to make sure that it was done within the law, to ensure that all of the policies were followed or applicable policies, to ensure that all of the evidence was weighed properly, and then make a final decision. So we're talking about 2 different levels of their most experienced people. And if upon reconsideration that decision is overturned, then they should allow the person to proceed to the fucking tribunal, the Workplace Safety and Insurance Appeals Tribunal, so that they can review it and they can make decisions and expedite all of this nonsense and all of these delays that are caused within the WSIB, with millions of dollars and resources just being flushed down the toilet, people's lives being destroyed, where they have to sit and wait endlessly for people to make decisions who are ill-equipped to make decisions, people who are overturning the opinions of doctors and using their own opinions to make decisions. That kind of nonsense should not be allowed. So if you have these frontline people making decisions, the system would be fair, the system would be much quicker, and people would be able to get justice at the tribunal because they know what the fuck they're doing. They follow the law. You just go on the tribunal website. You look at the quality of the decisions that they make and how they evaluate and assess the law and the policies and evidence, and they take it all into consideration. That's where you're going to get justice. But no, they've created more processes to delay the fucking process and cause people to give up. This is infuriating. It's shameful. It's disgusting. Absolutely disgusting. And you have all of these fat cats within the WSIB sucking up all of the oxygen and all of the money that comes in from employers that was supposed to go towards injured workers and their families when they need it, being spent in all of this crap. It's crap. All of it. Friends, as you can tell, this pisses me off, and I'm passionate about this, absolutely, because I see people getting screwed every day by a system that just, it shouldn't happen. It should not happen. And those who are holding it back, they're holding back change from happening. They're the ones that are stuffing their pockets, lining their pockets, and benefiting from a system that is broken. Where the people, those who are really the ones that should be benefiting from the system, are getting screwed, forced into poverty, forced into going back to work, hurt. It's sick. Absolutely sick. So this is the last time that I'm going to be talking about this appeal services division and all of the bullshit that they've created, because it's just totally fucking useless. And I challenge anyone at the WSIB, any one of those people at the WSIB, from the president and CEO, Jeff Lang, all the way down to the appeals branch. Every single person. I challenge any one of them to sit with me and do a live interview with me. Just one-on-one. Everything goes. No holds barred. They can pick the topics or questions that they want to ask me. I'll give them 20 and be generous. And I just want to ask 5. They get 20, I get 5. To talk about what's really screwing this system and what needs to happen to fix it. And then you decide. You judge. I'm prepared to do that any day, any time, with one eye closed and half asleep. But they don't have the balls to do that. They don't have a fucking person in that organization who has the balls to do that, who has the balls to sit with me and ask me 20 questions, and I'll ask them 5. Not one person in that organization has the balls to do that. But it's an open invitation, and it stands. For as long as it stands, it's open. They don't want to tangle with me. They're a bunch of cowards, and they know that they don't have answers to the 5 questions that I would ask them. All right, my friends, I'm going to leave you with the tip of the day, as always. Mr. Smiley's tip of the day. This is what Mr. Smiley has to say. Review your WSIB file to ensure that all relevant issues have been dealt with at the operating level before proceeding with an appeal. If you cannot identify and make sure that all of the relevant issues have been appropriately addressed at the operating level, you're going to find yourself in a game of ping pong between appeals and operating. Appeals and operating. Because at the end of the day, it's all about delay, delay, delay. We provide, with WSIB Settlements, my company, we provide a ton of tools that I personally developed based on over 30 years of experience, tools that work, that our members are enjoying today. They get access to those tools with our app. They get access to expert support and expert response to their questions on an immediate basis, usually within 24 hours, to help them make informed decisions. They're provided with support in the event that a case has to be reconsidered or appealed at the Appeals Services Division or the Workplace Safety and Insurance Appeals Tribunal. We want to make sure that our members are well supported, and this is something that you can benefit from. But one of the tools is our WSIB case audit and action plan. That is the best tool and the best thing that we can do for any one of our members and anyone who becomes a member with WSIBsettlements.com. Because what it does is it allows us to do an in-depth review of every aspect of your case. We also review your claim file. We go through it with a fine-tooth comb. We identify areas that are problematic that should be addressed. We identify any benefits that should have been paid but weren't. We also take a look at if your case is appeal ready, if in fact that's where you're headed, if there's been a decision and you're considering making an appeal. We do a very in-depth assessment, and we do provide a written report of our assessment of every aspect of the case that's been identified, as well as an action plan itemized in terms of what action should be taken and how in order to strengthen your appeal. This is a very powerful tool, and we also provide a guarantee because we know and believe in the strength of our experience. And so our guarantee is basically very simple, and I'll put it up on the screen. But if we're not able to identify any issues that are going to result in, at the very minimum, the cost of the fee to do this audit, which is $175, it's a one-time fee, then we will give you a full refund of that fee. No questions asked. If our report doesn't identify even one issue that would potentially result in you receiving at least the cost of the audit, then we will refund you, because we do believe in the strength of our experience, our expertise, our knowledge, and how we can help you with your case. All right, friends, if you're new to the channel, thank you for tuning in. As you know, or you may know, all of the information that I provide on this channel is free. Nobody's looking for money. We're up to over 150 videos in just 6 months, just a year, and we've got a ton more content to cover. If you need help with your claim, please visit our website, WSIBsettlements.com. If you need to email me for any reason relating to your claim, feel free to do so. My email address is joemachado@WSIBsettlements.com. If you're not a subscriber of the channel, I will welcome you to become a subscriber. And to my subscribers and my viewers, thank you very much for tuning in, for sharing my videos. Please give me a thumbs up if you like my content, and by all means, please comment. I always respond to my comments or to comments on my videos. Again, thank you very much for taking the time to watch this video. And as always, my friends, and until the next time, take care.